All right, here we go today. I warned you the last time that I like this chapter, I like this material, but I will present it from a distinctly cognitive bias, not bias per se, but from a much more cognitive perspective. Um, Keeping in mind that this is social psych class, and so the idea is that as I said yesterday, yesterday. What do you know when I recorded it, right? As I said the last time I recorded a lecture, I had said. No, I distracted myself. No. Oh yeah, I had said the simple example. The attractiveness of a defendant determines how much jail time they're given by a judge, and so clearly there are social factors involved that the justice is not blind, right? Justice is not blind. It should not be a social relationship. In the court of law, it should be the ultimate in logic. It should be, logic 101. But clearly it's not logic 101, okay? It's clearly much more than that, something different. So we're going to talk about some of that stuff as we go, okay? So, say for example, this is actually pretty good, the power of persuasive eyewitnesses. Eyewitnesses are awesome. If you want to end an argument, all you got to do is, somebody's back and forth, she said, he said, blah, blah, blah. All you got to do is say, I saw it with my own two eyes. That's it, buddy. End of discussion. We don't have this argument anymore about whether it's true or not because I saw it with my own two eyes. And that works really good to end an argument. And the thing is a vivid eyewitness account in a court of law is so much more convincing than a ton of circumstantial evidence. But yet there's social factors about different witnesses that make them perhaps more or less believable. All right. Oh, this is way too. This is a cognitive kind of a thing, but I'll give you the basic layout. This is a. I don't know. Some of you are familiar with hits, misses, false alarms, correct rejections, kind of a thing. Something that you must have pulled out of like your statistics class with type 1 errors, type 2 errors, correct. I forget even what you call them. Hits. I mean, we call them hits and misses and stuff, false alarms and stuff. But here's the deal. A person giving eyewitness testimony could be giving valid testimony or invalid testimony, and they could be given valid testimony in a situation where they could be saying, look, they witnessed the event and tell the truth about it. Or they could maybe they didn't witness the event, but they used circumstantial evidence to come up with the correct conclusion, right? So eyewitness testimony can be valid for multiple reasons, and it can be invalid for multiple reasons, okay? And so this is a more, this would be perhaps a way I might approach a cognitive class more. But suffice it to say, it's a good way to start, is that in a court of law, we're going to talk about the social factors involved, but the actual witnesses themselves may or may not be valid their testimony may or may not be correct for a variety of different reasons. And again, some of this stuff comes, at one point I taught a course called Memory and the Law, I called it. Memory and the Law. And it was a very interesting course, and it involves simply how memory systems interact with legal systems. And clearly that's cognitive in nature, so I can't say too much about it. But suffice it to say that here we go in 9. The 9th commandment, we find a clear indication already in our 10 commandments that thou shalt not bear false witness. That if a witness in a court of law is telling a lie, our social systems collapse. Right? That's what accusations are all about. Okay. And I don't want to get into a lot of it, but suffice it to say, here in the Constitution, this is the Constitution of the United States, we find, look, I mean, where is it? You got to have witnesses in order to be called treason, that the idea of an eyewitness is so deep. Nature and cause to be confronted with the witnesses against him, eyewitnesses are built into our very fabric. Okay, as I said at the very beginning, if you want to end an argument, you're having an argument with somebody, you just say, I saw it with my own two eyes. Done. Right? End of argument. You really got to... How's the other person respond to that? No, yes, I did. I saw it with my own 2 eyes. Oh, I got nothing back on that. I got no argument back. Well, that is how eyewitness testimony is treated. All right, so now here's a very, 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 very famous case. Here's a good social psych lesson. I'll try to present it as a social psych lesson, as we should, as I keep saying. Sacco and Vanzetti. This is the original trial of the century until 1,000 others took over, including the Lindbergh baby kidnapping and obviously O.J. Simpson at some point. But anyway, this was the original trial of the century. Nicola Sacco and Bartolomeo Vanzetti. I finally get to use my Italian. So, Mrs. Annie Nichols saw 2 men leaning on a fence. She saw 2 more men appear, a factory cashier and a bodyguard. One of the men leaning on the fence shot the guard and the cashier. A car came up, and the 2 men jumped in and took off. Okay? Crime is over. Multiple witnesses to this scene. None could give an accurate description. When they asked him, can you describe the perpetrators? You know, I don't know. One witness goes, oh, he was awfully dark. Another one goes, no, it was really light-skinned, like a Finn or a Swede or something. And then another one says, the driver has a mustache. And then that same person says, you know what, I don't think the driver had a mustache. Now I think that the driver was clean-shaven. Okay? And so all of these different things, but what was a statement, this is just as a fact, is that the weapon that was used was the .32 caliber pistol. Okay? That was indisputable. So now, Nicola Sacco, a shoemaker, and Bartolomeo Vanzetti, a fish seller, were arrested. Neither one had a criminal record. They both were armed, and Sacco had, in fact, a .32 caliber automatic pistol, which is a fairly common weapon. I mean, it's a whatever. So then what did they do? They invited witnesses to jail and said, hey, are these the bad guys? Remember, they had already asked the witnesses, can you describe them? And they're like, maybe dark, maybe light, maybe mustache, maybe no mustache. I don't know. Instead, here it is. We're going to bring you into a jail cell and ask you, are these the bad guys? At trial, all of a sudden, remember now, nobody could describe them, but now all of a sudden at trial, 5 witnesses identified Sacco. Now let's look at these 5 witnesses. One had previously testified that her opportunity to view robbers was too limited to say that Sacco was one of them. Previously, one of the witnesses had told the policeman she had not seen the faces of the robbers. Okay. One of the witnesses had claimed that she had not seen enough to identify anybody. A 4th witness had told 3 different people she would not be able to identify any of the robbers. Yet in the court of law, Sacco did it, Sacco did it, Sacco did it. This is the guy. Okay? 4 witnesses placed Vanzetti at or near the scene of the crime. One told a friend he had ducked as soon as he saw a gun, and he wouldn't know the robbers again if he saw them. The friend related a conversation, and yet, lo and behold, the witness said, you know what, that's him. Reports indicated that no witness could initially identify Vanzetti, but when they showed a picture of Vanzetti over and over and over and over, eventually the witness is like, you know what, that is the guy. Vanzetti, however, poor Vanzetti, was also accused of an attempted holdup the previous year. Okay? In this previous crime, a witness had told the police twice that they would never be able to identify a perpetrator. Then that witness was brought in to see Vanzetti, and then pretty soon this witness produces a perfectly accurate description of Vanzetti. Okay? Now, that's pretty amazing. Now, Vanzetti was found guilty, and he has his 12 to 15-year sentence hanging over his head, and now he's brought back to trial on this murder charge. Okay? So, that's a big bad boy to begin with. Now, he's got to deal with that. Now, both Sacco and Vanzetti had alibis for the day of the factory murders. Okay? Sacco had taken a train to Boston to go to the Italian consulate. As, by the way, this is important. He's Italian, okay? To apply for a passport. And the clerk remembered Sacco very well because it was so silly. He had brought this big family photo, and it was like, here, can I use this, for my passport? And they were like, dude, you got to have the face shot, the whole... You can't just chop a picture out of the middle of a family photo. Give me a break, okay? Vanzetti had been selling fish in a different town, and in fact, a merchant remembered selling him some cloth. So clearly they both had alibis. Okay. The jury believed the eyewitness memory over the alibi witness memory. Let me think about this. Mrs. Annie Nichols, if that's a name to be reckoned with. What does that sound? I don't even know what ethnicity that sounds, but it's not Italian, I can tell you that much. The person at the Italian consulate was probably Italian. If my memory of this situation is correct, at this point, the Italian population was isolated very much, so it wouldn't surprise me if Vanzetti's interactions with a fish seller also involved, or with the cloth dealer also involved an Italian. So what happens is they were both sentenced to death, and Vanzetti at the time of his death, I wish to tell you that I am an innocent man. I never committed any crime, but sometimes some sin. I wish to forgive some people for what they are doing to me now. Okay? Pretty impressive. So now, what we find is that, what was Sacco and Vanzetti's biggest crime in here? If I had to make a guess, being Italian. All right? Were they good guys? I don't know. Were they guilty? I doubt it. Okay? I doubt it. However, they were sentenced to death, and they were put to death, and I think that the fact that they were Italian played the largest role in this trial. Flash forward to the Sawyer brothers. So there was a crime, kidnapping a store manager at gunpoint, and the manager was forced into a car, and two kidnappers quickly pulled masks over their faces, and the manager tells the police one of them looked Hispanic. The manager also tells the police one of the men looked like somebody who had recently applied at the store. Okay? Now, Sandy and Lonnie Sawyer were pulled over in a 1965 white Plymouth Valiant. Wait a minute. A Plymouth Valiant and a Dodge Dart are not the same car, right? Did I put that on the next slide? No, I didn't. Okay. They are not the same car, right? And neither Sandy nor Lonnie Sawyer looked like the composite sketch that had been created, and neither had applied for a job. Okay? All of a sudden, they're in trial. And what happens is the store manager's original description, one looked Hispanic and one looked like a guy who recently applied at the store, this was not information that was given to the defense attorneys. Okay? Instead, at trial, the store manager identified the Sawyer brothers as the kidnappers. Okay? 4 alibi witnesses said Sandy Sawyer was at home at the time of the kidnapping. 4. 4 alibi witnesses said Lonnie Sawyer was at a printing plant visiting his girlfriend at the time of the kidnappings. The jury deadlocked. The judge says, hey, try harder. A couple minutes later, they all voted guilty. So now let's look at the math here. I mean, this just isn't hard math, right? You have 1 witness say yes. We have 8 witnesses say no. Okay? How is it that 1 witness trumps 8 witnesses? There's no evidence. There's no forensic evidence. There's no hair at the scene of it. There's nothing. There's none of this fancy CSI, none of this stuff, right? So how the hell is it that 1 eyewitness is believed over 8 alibi witnesses? Okay, let's take it further. There's a rumor in jail that Robert Thomas had claimed that he was a kidnapper. The kidnapper. One of them. A private investigator talked to the manager and discovered those things that the defense had not been told, in particular that the kidnapper looked like somebody who had recently applied for a job. When you look through the job applications, guess whose name pops out of the job applications? Robert Thomas. Wait a minute now. So now, despite all of this, the judge says, no, sorry, too much time has passed. We can't have a new trial. Robert Thomas confesses in writing, on camera, recants and recants the recantation. Eventually, the Sawyer brothers were set free and probably given, $20 for each year they were in prison or something. So what happened? What went wrong? Okay? Well, just like in the first part, what happened was the Sacco and Vanzetti were guilty of being Italian. If I had to make a guess, I don't know the Sawyer brothers. I'll look them up someday, but I guess I don't want to. I know, here's a stereotype for you. Your girlfriend works at a printing plant. Chances are you are not a rich person. You are not a member of the upper class if you have a girlfriend that works at a printing plant. I don't even need any more details than that. So what it comes down to is not one witness trumps 8 witnesses, but one fine, upstanding citizen, a store manager, trumps 8 not upstanding citizens, perhaps. I don't know. I don't know who they are. I am taking that stereotype, I admit, but if you have a girlfriend that works at a printing plant, it probably tells me certain things, other things about you. Okay? Now, this is terrible, though. 8/1. And now, before I go any further, well, here, let me read. On the one hand, eyewitness testimony is very believable and can wield considerable influence over the decisions reached by a jury. On the other hand, eyewitness testimony is not always reliable. It can be flawed because of normal and natural memory processes, cognitive, or it can be flawed because of social factors. Okay, I'm going to tell you a little side story. I remember one time I was living in New York, out in Long Island. It was just a terrible place to live, and they have this crazy system where they have stores, shops right along the highway. So basically, you have to merge onto the highway from a dead stop. Okay. You don't get it, there's no ramp to merge. You're at a stop sign, and you have to try to get onto a highway where they're driving 70 miles an hour, like this. Okay, so one time I was at Burger King with my wife, and she was pregnant. And we were driving a Geo Metro. If anybody remembers a Geo Metro, there's 3 cylinders, okay? So that means that not only are you having to merge onto a highway running 70 miles an hour starting from 0, but you're doing it with 3 cylinders, okay? So clearly I had to be incredibly patient. So I'm sitting at the stop sign waiting, and the guy behind me clearly was not patient, okay? And he just rammed right into the back of my car, just totaled it, put my wife in the hospital. She was in having contractions at 6 months, pregnant. And, it was really, really, really bad. So when we start talking to the police, I find out from the police a simple statement, which is just shocked the living shit out of me. He said, okay, you're so lucky that guy did not have his girlfriend in the truck with him. Because if they would have just said it was his fault, I would have been screwed. I would have been like, yeah, but my wife would have been my witness. They go, no, sorry, your wife can't be your witness. What? No, she's your wife, and so therefore, by definition, her testimony would be biased, so she can't count as a witness for you. But if this dude had a girlfriend, then that would be okay. Sure. And they were going to get married tomorrow. That's right. Okay? A girlfriend, and you're going to marry her tomorrow, that can be a witness. But the day you marry her, she cannot be a witness. Now, I understand the logic behind it. I do. Because it is a job of a spouse to stick up for. Now, I got lucky, as I said, because it was, my testimony against his testimony. Put that together, and then, look at my Geo Metro. It was totaled. So you put these together, and it became obvious whose fault it was, and the insurance company paid accordingly. But it was a legitimate thing. It was a legitimate thing to dismiss my wife as an eyewitness. I understand the necessity for that. I do, and I'm wondering if some of that type of thing might have been going on with the Sawyer brothers. Okay, remember now, Lonnie Sawyer has 4 friends who all say, no, he was at home with us. Dude, they're friends, okay? Technically, they have the full ability to be a witness, right? As I said, my wife has not even the legal ability to be a witness. But you got to remember what's happening is that the jury is sitting there dismissing testimony because of these relationships, okay? For all we know, these are Lonnie Sawyer's drinking buddies. They were sitting at home watching a football game getting drunk. What do I know, okay? But these are his drinking buddies. Does a drinking buddy really have the same credibility as a witness that doesn't have a social relationship with the accused? Yeah, it does. So we're going to come back to a question like that in a little while. It's going to be on the final exam, and it's one of my favorite questions. So I'll come back to that in a bit. Here's an interesting study. This was Gordon Allport, one of the original personality researchers. He's a founder of trait theory, the trait theory of personality. But anyway, in a 1947 experiment on rumor transmission, he shows this picture, and in this picture, it's hard to see it, but it's basically a subway car, and you see in the picture there's two people having a confrontation, a white man and a black man, and in this image, the white man is holding a razor blade. And so now they play one of these games where, okay, your job is to describe this picture to the next person. And then the second person's job is to describe to the third, to the fourth, but only the first person has seen the picture. By the time it got to 6 tellings, the razor blade in the white man's hand almost always shifted over to the black man's hand. I mean, that's how eyewitness testimony works. Okay, it shifts. We find that stress reduces eyewitness ability, which is kind of a troublesome thing in the first place, because if you're being asked to be an eyewitness or something, chances are it was a stressful event, right? I mean, that's the definition. Otherwise, you wouldn't be witnessing it. There's also people that have a lot of life stress are worse at being witnesses. Some say males are better at being witnesses, and some say females are better. And it really comes down to what is being witnessed. If you're asking about a type of car, you ask a man to do it more often than hey, I know it's a stereotype. And if you need to know what kind of a purse a woman is carrying, don't ask me. All right, I just ain't got it. So females are better at witnessing certain things like clothing and actions. Men are better at witnessing things such as appearances and surroundings. These are just because we pay attention to different stuff. There's a relationship between eyewitness ability and age, blah, blah, blah. That's more cognitive. I don't want to. Children, here we go. This is interesting. Children are very suggestible. That is to say, children are subject to social influence. That is, they they like to get the approval of grown-ups that they respect. And so what happens is children, very, very simple. See, the problem is that when somebody goes, let's say there's a witness, and now you have somebody that's going to interview the witness. In theory, the person interviewing the witness is supposed to be absolutely and utterly neutral, okay? But they're not. They're not. Usually, especially in atrocious, in terrible crimes like crimes against children or something, there's a strong bias, okay? We all know the little phrase, innocent until proven guilty. That's true. But let's say the interviewer is interviewing a child about some incident that may have happened or may not have happened. The interviewers may have such a bad feeling and bad taste about crimes against children, they're going to be biased in the way they ask their questions. And it's pretty straightforward that you can... It's pretty easy to make a child say just about anything, okay? There's been some interesting studies showing that even you can get college students to remember things that didn't happen. It's not hard to do. That's more cognitive than anything. That's not saying children are stupid. They're very bright. But the problem is they're often being interviewed by people that have a bias, okay? Bias either for defense or prosecution, usually prosecution. And so we find that children can be, I mean, they've done studies, like one study, say, for example, they took kids, and the doctor, they took children, they took 100 kids, they took them into a doctor's office, and the doctor did a simple examination, check the ears, check the eyes, whatever, just kind of a routine thing. And then they asked the kids, later, what happened during this thing. And these kids were making up all kinds of things. But, I mean, they were truthful. I mean, that is to say the kids believed that they were telling the truth. One kid even said, the doctor put the stick and put it up my butt. All right? And I was like, come on, dude, there was no butts. There was no, it was just a, let's check the eye, ears, nose, throat kind of a deal, right? And so if a kid spontaneously comes up with, the doctors put a stick up my butt, spontaneously, without any probing or any, what did the doctor do with the stick? I mean, if you asked 100 kids about what did the doctor do with the stick, yeah, you're going to get 20 of them saying he stuck it up my butt. One kid does it without even probing, without even, actually, that's kind of a creepy statement. Okay, without even probing, without even asking, without even requesting this piece of information about the stick, the kids spontaneously came up with it. So if 1% of kids are spontaneously coming up with such a thing, just imagine how many would come up with it if you had a biased interviewer in the first place that had some preconceived ideas. Yeah, like say for example, they have these anatomically correct dolls that they use when they use children as witnesses. Again, this is a lot more cognitive, but again, if you give children these little interview dolls and you just let them play with them, they have these clinical dolls that they use and everything. And if you just let kids play with them, the first thing they do is they take the pants off the doll and start poking their fingers up the you-know-what parts, right? It's just what kids do. And so now you're going to take this doll and you go, show me where he touched you. We already know the most fascinating part about that doll is going to be the private stuff. So, gee, what do you think the kids are going to be doing when you ask them this question, okay? Oh, yeah, here, that's the whole... All right. Here we go. This is... I did this one earlier, right? Yeah, I did this one when I talked at one point about how we fill in the blanks with what we think was there, and then our entire memory system changes as a result. Yeah, we talked about that. And so that whole notion that memories change with time, that whole notion that memories are not like not like putting money in a safety deposit box and you come back and get your money back. Remember that? No. Memory is more like you put money into a safety deposit box and you come back in a week and damn, you might have more money in there, you might have less, you might have foreign currency, God only knows what's going to be in that safety deposit box. And a lot of evidence shows that the things that happen in a person's life between the time of the witnessing of the occurrence and the time that they present it at trial, what's going on in there affects the memories. Clearly it does. It changes the memories. Yeah... As I said, there's a huge social component to memory formation. This one study here, Lost in a Shopping Mall, check out the video. It's very interesting. But in this one, what they basically did was the researchers called up, they got some volunteers for an experiment, and then they called up the parents of these kids. These were college students, right? Called up the parents and said, tell me 4 things that happened to your child, okay? And then they said, okay, now to the parents, they said, did your child ever get lost in the shopping mall? And all of them said no. So now the experimenters were armed with 4 pieces of information which had been confirmed by the parents and 1 piece of information now that did not happen. And so each of these volunteers were now presented, okay, here's 5 things. We talked to your parents, and here's 5 things that they said happened to you. Okay, we want you to write about these, to write them down and tell us about them. And, so 4 of them actually had happened, and 1 was this made-up thing. So many of the people right up front said, no, I don't remember this. He goes, no, okay, just you got to go home. Your job is to write things, okay? And so people went home, and their homework was to write 2 paragraphs about each of these 5 things. And lo and behold, in almost every case, it was a rare thing that the people did not come up with the story behind Lost in a Shopping Mall, okay? Even though we now know that every single one of these, it didn't happen, yet almost every single one of them came up with oh yeah, I remember that. I can still remember the guy that when I found, oh my God, I was so scared, and he was wearing a hat, and I remember the cologne he was wearing, but he was such a nice smile. And he took me by the hand, and he took me to the office. I remember that. And all of the details are filled in. And these are college students, okay? So clearly when there is a bias to remembering something, people will remember it in that manner, okay? And so the court of law is not isolated from that. Hidden assumptions. Yeah, this is interesting. When questioning a witness to a robbery, the police might ask, how tall was he? This implies 2 things. Number 1, that the person that was committing the crime was male, and that the person committing the crime was in fact somebody tall. Okay? So there's 2 different assumptions being made when these questions are asked, and people's memories will fit accordingly. There's no problem with that. This is a lot more cognitive again. Yeah, blah, blah, blah. Uh, Suffice it to say, at someplace like a police lineup, there is those social factors involved, such that people assume that there is a bad guy in there, and that their job is to pick the bad guy. They're basically seeking social approval from the police department and stuff. There's a lot of social components to it. Okay, go on. What does this say? Oh boy, that's a lot of questions. Okay, I guess here's you can read all of these. They're very interesting, but what really what are the point of all of these? There's a lot of stuff here, but the point of them is this, okay? That when you read these things, eyewitness experts that believe it's true, let's say whatever the first one is, the way you okay. An eyewitness's testimony about an event can be affected by how the questions put to that eyewitness are worded. Okay, 95% of the experts say, yeah, that's a true statement. 85% of jurors believe that's true. Who do you think is correct? In fact, look at the next one. Lineup instructions. Police instructions can affect an eyewitness's willingness to make an identification at a lineup. 98% of the experts say, yeah, that's true. Only 41% of jurors agree. What's the point here? The point is, now don't get me wrong, I'm not bad-mouthing it, but here in America, you have the right to trial by a jury of your peers. Okay, that's awesome. But dare I say that your peers are kind of morons, right? Look, at only 41% believe that's to be true. Therefore, that is what you have to work with in a court of law. Not the truth. The truth doesn't matter anymore. It's what you can convince a jury. And only 41% of jurors agree with this statement of fact. So, if only 41% of jurors agree with this statement of fact, just imagine now, a good lawyer knows that only 41% of jurors know this, even though it's true, and will use that information accordingly, okay? So it's crazy. It almost makes sense to have a set of professional jurors, but alas, I mean, you know, whatever. So anyway, here's one of my favorite questions. This one, I've used this a long time, and it's a good one. It's a very good one. This is on your final exam, so it's preparing you for it. And this is really, the ultimate in, what do we call it? The ultimate in critical thinking, because it involves your opinions but backed up by facts. Why is the testimony of some people given more weight when a jury considers the facts of a case? Remember, my wife didn't count. Remember, Lonnie Sawyer's drinking buddies didn't count. Remember, Nicola Sacco and Bartolomeo Vanzetti's Italian witnesses just didn't have the oomph. Okay? Give your opinion supported by fact and evidence about whether this practice is morally and ethically good or bad. Okay? So it is happening. That's a fact. Okay? Why is it happening? Is it legitimate? It makes sense to say my wife cannot be a witness. Does it make sense then that the jury would discount Lonnie's buddies because they're drinking buddies, and of course they're going to support Lonnie? Is it the jury's right to do so? That's what the jury does, but is it the jury's right to discount them? Okay? Give your opinion about whether this is good or bad. Now, I want you to think about it. Very, very simple. If there's a witness on the stand, the simplest way to discredit that witness is a character assassination. Weren't you at a mental hospital 12 years ago? Yeah, I thought so. Okay. And the judge says, strike that from the record. Well, guess what? It's already in the jury's mind. It's got nothing to do with nothing. Or say, for example, one of my things that really make this stick out. I guarantee you, absolutely and utterly guarantee you, if I were pulled into a court of law to be a witness for something, okay, and I haven't been, but I can guarantee you that the people that wanted my testimony, you know, they would introduce me as Dr. Brown. That would be, I mean, there would be no doubt in my mind that they would introduce me as that, because it would raise my credibility as a witness to the jurors. Now, my being a doctor has nothing to do with whether or not I'd be a good witness. It has zero to do with it, okay? My educational experiences have nothing to do with whether or not I'd be a good witness. Yet, lo and behold, that is exactly how they would introduce me to raise my credibility, to give it more to the okay, so now, all of a sudden, we find that, say, for example, another one that always I think about was the back in about 2004, 2005, something like that. The Duke University lacrosse team and the woman that was accused the team of raping her. And if you recall that rape case, there are certain facts of the case that were brought out that were perhaps not relevant, okay, but yet were brought out, okay. Number one, she had previously been in a very similar situation where she had accused somebody falsely and admitted that it was a false accusation. So now she's accusing somebody else. Do we now discount her testimony because in the past she admitted to giving false testimony? Has she now, by that one act, given up her you know, I don't know, what do you call it, freedom? No, has she given up her right to do this? I mean, has she sold herself out? Okay, then guess what else they attacked on her? They said, okay, look, she had sex in the car on the way to this party. She had sex in the car with two different men, and it was consensual, on the way to the party where she claimed she was raped. Does that have anything to do with her ability to be a witness? Yet, that's what happened, was they pulled a character assassination on her and absolutely and utterly discredited her ability. And I mean, if I had to look at that case, I would say it was a load of shit. I mean, I don't think there was anything there, but of course I was not there. I can just see the evidence. Now, was it right? Okay, was it right for her to lose? She just totally lost her ability, her right, dare I say right, to stand up in a court of law and confront her, the perpetrator. But it was taken from her. She had no ability. And by the way, following up on this, oh my God, this woman involved in this case, about a year ago, she killed her live-in boyfriend. She stabbed him. Yeah. I'm thinking maybe there's something wrong with that woman. So anyway, the main job of the trial lawyer is to get the jury to like the defendant. Okay? I told you to come back to social. Look at this in the corner. I love this. And so I asked the jury, is that the face of a mass murderer? It's a little smile. All right, come on. That's cute. And so what we find is that the more you can get a witness that speaks more confidently tends to be influential to the jury, right? These are the social factors involved. Attractive defendants get lower penalties. Take a look at the graph in the bottom left there. We see for not so much, though it's true for minor misdemeanors and also for moderate misdemeanors. Let's look at the serious misdemeanors, the most obvious. The amount of fine or bail for an unattractive defendant accused of a serious misdemeanor is $1,400. The average bail for a serious misdemeanor for a highly attractive person is around $600. So that's less than half the bail, less than half the fine if it's an attractive defendant. Okay, defendants that are similar to the jury tend to get better treatment. That is why so much work is done by the lawyers to try to select an appropriate jury. Race is an important component in previous convictions. Okay, here. We already said this. Jurors cannot ignore evidence that has been presented. So when they say, didn't you have sex in the car with two different men on the way to the party? And then what am I trying to say? I guess it would be the defense would say, the defense lawyer would say that. The prosecuting lawyer would go, Judge, that's irrelevant. And the judge would say, I agree, strike that from the record. Jury, ignore that statement. The jury can't ignore that statement. I mean, it's been put out there, all right? That's just how it is. Once it's out there, the jury does not ignore it. This is really interesting. Some of this stuff. Dare I say, first impressions in a court of law. That is to say, if you happen to be accused of a crime and you end up going to court, you put on your Sunday best. If you're a man and you're wearing an earring, take out the damn earring, okay? Because yes, stereotypes matter to both the judge and the jury. And once a negative opinion is formed, it will take 100 positive statements to take care of that one negative. If you just start on a neutral, it's much easier to pull yourself into positive territory. Characteristics of the victim. Yeah, this is absolutely interesting. I love this one. Again, it's more cognitive than anything, but I guess it's social. Here's Bernie Goetz, and maybe you remember Bernie Goetz a little bit. He was something else back in the 80s. He was really a national celebrity. So it turns out that basically New York City crime had just gotten to the tipping point. It was just really bad in New York City. Especially the worst was these subways. And now here's Bernie Goetz. He just had enough. He had just been mugged on the subway like the day before or 2 days before, very recently. And he was just done. He, he had talked to enough people, and he said, "I'm just done. The thugs have taken over my city. I mean, they don't even pay to get on the damn subway. They jump the turnstiles. I'm paying to get on the subway. I am subsidizing this through my taxes. They don't even have a freaking job, and they're robbing me. I can't even sit. I can't even." And I mean, I was on the subway in the late 90s out there, mid-90s, with a native New Yorker, and he said, "Okay, this is it. This is the rule. When you get on the subway, you look at the floor. You do not look at another human being. You do not make eye contact. You do not talk. You just look at the floor and wait for your ride to be over. That's how you ride the New York subway." I was like, damn, okay. So anyway, Bernie Goetz is all freaked out, so he gets on there with a gun. And he decides he's going to get a little bit cocky. So there's some thugs in his opinion, some gangster kind of guys. And he approaches them, basically, and sits down right next to him. Now, come on, that's already a faux pas, right? I mean, these dudes are like, there's these unwritten rules on the subway where if there's a group of troublemaking kids that look like they're troublemakers, you don't sit there, right? Well, he did that. He sat right down, right where they were in, okay? And so what happens is, according to Bernie Goetz, is they came up and they were like, hey, dude, give me your wallet, And Bernie Goetz is like, "You want my wallet?" He reaches in, pulls out his gun, bang, shoots the guy, okay? And they didn't die or anything. Well, turns out now that Bernie Goetz was the criminal, but it turns out that the victim had all kinds of criminal record. Okay, and so all of a sudden in the public eye, and in fact the eye of the jury, Bernie Goetz was a hero. He was a subway vigilante, man. I mean, the dude is a hero. But guess what? He's the criminal. He's the guy on trial, right? He's on trial for shooting a guy in the stomach or something, okay? Now, some of this stuff is like, this is really interesting. No, not that one. Bernie Goetz was something else. Here was some interesting comments. Read these. These are just great. I remember what the New York subway system and streets were like back in the 80s, and while I sympathize with Goetz, I suspect, well, okay, going on. Take a look at these. These were comments that I pulled out of, from the bottom of an article from someplace. But lo and behold, okay, Goetz did not go to jail, or if he did, it was very trivial, like a week or time served or something. But lo and behold, again, follow up on it, and these two boys that had been involved in this, they later on, they ended up, oh boy, they sexually molested a mentally retarded girl and threw her off a roof or something. And it was like, Jesus, maybe Goetz was on to something there. Whatever. Never mind. Jurors, as we said, jurors are human with human limitations. Not just human limitations, like I said, it's a beautiful thing. A beautiful thing that we have this guarantee written into our Constitution that we get a jury of our peers. That is a beautiful thing. But our peers, I mean, when I say our peers are morons, I don't really mean it quite like that, but our peers don't have legal training. They don't understand. And so they are easily persuadable. Literally. Because, like I said, in a court of law, it ought to be 100% logic. It ought to be no emotion. It ought to be fact. But in fact, it is not fact. It is, in fact, who can convince who of what. And so, honestly, I'm going to tell you, though I hope I never end up in a court of law, I'm telling you something. If you get accused of a serious crime and you need to go to court, you get the best lawyer you can get. You borrow money. You go bankrupt. You do whatever. You sell your house. You do anything you can to get the best lawyer you can, because in a court of law, truth doesn't matter. It's what the lawyer can convince the jury and the judge. And it's all got to do with simple things like likability and using the right words to sway people's opinions. And so it is just a social psychological experience to the extreme. Remember we talked about that overconfidence thing? I could lay this up, but remember we had talked about how, in fact, just recently we had talked about mildly depressed people tend not to show this, but as a general rule, people display overconfidence, and this overconfidence has been shown to extend to the court of law based on the number of wrongful convictions that they find and everything else. This overconfidence, because the problem is, of course, in a court of law, the jurors are told, you must be certain of the guilt beyond a reasonable doubt. Okay? But you're never told, what does that mean, reasonable doubt? What is reasonable doubt? And so, lo and behold, people's overconfidence in all things extends to the court of law, and this reasonable doubt comes into play. Yeah, I had already said that. Selecting a jury is so important because certain characteristics of the jury, like very simply race, is a major component. But here, let's say if you ask a potential juror their opinion of drug use, it'll give them an opinion, give the lawyers an idea how they're gonna react to drug trafficking charges. You know, or people that say they don't put much faith in the testimony of psychiatrists are much less likely to accept an insanity defense, right? So these lawyers are gonna look at characteristics of the jury and select them accordingly. John Grisham, the movie here, Runaway Jury, that was a really interesting movie, and it shows you how much of well, I mean, it's fiction in many ways. I mean, realistic fiction, and I'm sure there's a lot of truth to it. But in that movie, we find that the truth is, I mean, the truth of the trial just doesn't even matter after a while. In this story, it's just like it doesn't even matter who's guilty. It matters what you can convince a jury, and what you can convince a jury really is based on what kind of jury can you get on there in the first place. Okay. Crazy business. Blah, 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 blah. I don't remember that. Deliberating juries become more lenient. Blah, 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 blah. Group deliberation. Group influences. The opinion of the jury. Okay, yeah, the juries tend to come together. Yeah, blah, 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 blah. Okay, so that's all I got into this one. As I said, I have so much more on this material, but it's so much more cognitive in nature, and I'm just trying not to throw cognitive into there. I'm trying to make it social. So I want you to keep that in mind, is that, seriously, that simple statement, how much can you get the judge or the jury to like the defendant, is the most important thing you can be. And as we see, more attractive is more likable. If the defendant is the same race as members of the jury, is more likable. If, you know, your defendant smiles a lot, he's more likable. I mean, it's really just, it's a game of social skills. Who can convince who of what? Okay, so it's I'm kind of bitter, kind of pessimistic about our legal system, and it's too bad. But I'm very pessimistic. I don't think that fairness really plays much into it. Whatever. We'll come back next time and we'll finish up our very last chapter in the book. Man, we are getting so close to the end, I can smell it and taste it. Alright, see you next time.